You're building your brand, logo finalized, website live, maybe even some sales coming in. Then one day, out of nowhere, you receive a legal email. Subject line: cease and desist, trademark infringement. And suddenly you think, wait, what? You didn't copy anyone. You just picked a name you liked. So how did this even happen? Receiving a trademark infringement notice in India is serious, but it's not the end of your business. What you do next is what actually matters. First, understand what this notice really means. A trademark infringement notice is not a court order or a penalty. It's a formal warning. Someone is claiming that your brand name, logo, or tagline is too similar to theirs and they want you to stop using it. Now, the question is, are they right? What not to do? First, do not ignore it. If the other party moves legally, your non-response won't help your position. Second, don't panic and shut everything down overnight. Many founders delete websites or change logos within 24 hours out of fear. And don't send an angry reply saying, "We are not copying you." Trademark disputes are resolved through law and documentation, not arguments. What you should do first, read the notice carefully. Who sent it? Is it from a registered law firm? Have they mentioned a trademark number? What exactly are they asking you to stop using? Second, verify the trademark. Search the trademark number on the Indian Trademark Registry website. Check. Is it actually registered? In which class? When was it filed? What goods or services does it cover? Trademark protection in India is class-based. For example, if they are registered in class 25 for clothing and you operate in class 41 for education services, the situation may be very different. Third, compare both brands honestly. Are the names visually similar? Do they sound similar? Are you in the same industry? Could a customer realistically get confused? Trademark law mainly focuses on likelihood of confusion. If customers can mix up the two brands, that's where risk begins. What usually happens next? After reviewing everything, there are usually three possible paths. 1. You defend your position. If your brand is genuinely different, a properly drafted reply can resolve the issue without going to court. 2. You negotiate. Sometimes small adjustments solve everything. A logo tweak, a disclaimer, or a slight modification. 3. You rebrand. It's not ideal, but sometimes it's the most practical decision, especially if the other party has an older registration in the same class. Important reality. Check: receiving a trademark infringement notice does not automatically mean a lawsuit has been filed. You owe compensation immediately. Your business must shut down. Most disputes start and end at the notice stage. When should you take it very seriously? If the other party has an older registered trademark. You are in the same class. The names are almost identical. You are actively selling under that brand. Then you should act quickly and carefully. Where professional guidance helps. This is where many founders seek legal guidance. Not because every notice leads to a legal battle, but because assessing the risk correctly is important. Sometimes the notice is weak. Sometimes it's strong. Sometimes settlement is smarter than fighting. At EbizFiling, when founders approach us with such notices, the first step is to remove panic and evaluate the facts. Because trademark disputes are not about fear. They're about position, documentation, and strategy.